So today, we're going to unpack a neighborhood dispute that went all the way to court. It all started with a late payment and a single, pretty fiery email that tried to topple an HOA's leadership. And believe it or not, the whole thing hinges on one surprisingly tricky question.
I mean, really think about it. Can one person all by themselves just fire off an email and get another board member kicked out? That's the question that kicked off this whole legal mess. So let's get into how it all went down.
Okay, so here's the plan. First, we'll look at the complaint itself, and then we're going to dig right into the HOA's rulebook. From there, we'll trace the timeline of this so-called automatic resignation, break down the wild one-man vote, and of course, see what the judge had to say. And stick around, because at the end, we'll talk about why all this drama actually matters to you.
All right, first up, the complaint. Now you might be thinking this is your classic disgruntled homeowner versus the board situation, right? Nope. This fight actually started from inside the house, so to speak. We're talking about one board member taking on his own association. So let's meet the key players here. The guy who filed the petition, his name is Richard P. Quinn, and he's a board member. But his target wasn't some neighbor with an overgrown lawn. Nope. It was his own HOA, and the whole case was about the status of another board member, Karen Igo.
Okay, so here's the heart of Mr. Quinn's argument. He basically claimed that Miss Igo was more than 30 days late on a payment, and because of that, the rules meant she had, get this, automatically resigned from the board. But as you're about to see, that one little word, automatically, is where everything gets, well, complicated.
You know, in a legal showdown like this, opinions don't really matter. What matters is what's written down on paper. So let's pull out the HOA rulebook and take a look at what the bylaws actually say.
Okay, so check out the exact wording here. It says that being delinquent shall automatically constitute a resignation. Now, at first glance, that seems pretty clear, right? Case closed. But the sentence doesn't stop there. And that last little bit, that's what this entire case is all about.
And here it is, the big catch. The resignation isn't actually final the second a payment is late. It only becomes official, and this is the key, when the board of directors accepts it. This totally changes things. What looked like a simple, automatic thing is actually a two-step process. First, the delinquency, and second, the board has to accept it.
Okay, so now that we know the rule, let's walk through the timeline of events. This is where you'll see exactly how this whole thing went down.
Okay, so let's break this down. Back in March of 2019, a pretty big wall charge shows up on Ms. Igo's account. For the next few months, she starts chipping away at it, making these partial payments. But then, bam, on October 18th, Mr. Quinn sends that email trying to force the resignation. And you've got to pay attention to the timing here because just 3 days later, Ms. Igo pays off the whole remaining balance. He tried to act in this super narrow window.
And this brings us to what is honestly the wildest part of Mr. Quinn's whole plan, the one-man vote. Seriously, he argued that his single email was enough to speak for the entire board. Let's see how he even tried to justify that. So on that day, October 18th, Mr. Quinn shoots off this email to the board, saying he accepts the resignation. Nobody else replies, not a single person. So he makes this incredibly bold claim. He actually cites Robert's Rules of Order and says, well, the vote is 1-0. Since he was the only one who voted, he argued he had the majority. Yeah, really.
But you know, this is where his argument just slams into a brick wall of reality. Mr. Quinn thought his solo email counted as a real vote. The bylaws, on the other hand, are super clear. For the board to do anything official, you need a duly held meeting with a quorum present. And a one-person email chain, that just doesn't cut it. Not even close.
So that raises the question, what exactly is a quorum? Well, the HOA's own rules define it pretty clearly. It's a majority of the directors present at a duly held meeting. Basically, just think of it as the minimum number of people you need in the room to make a decision legally binding. If you don't have a quorum, any vote you take is worthless. And just to be clear, one person sending an email is, by definition, not a quorum.
So, eventually, this whole mess lands in front of an administrative law judge. So how did they rule? Well, the whole decision really boiled down to this one fundamental conflict: an informal email versus the very formal requirements of an official board meeting.
The judge's ruling was just a masterclass in dismantling this argument piece by piece. First, the bylaw says the board of directors has to accept the resignation, not just one guy. Second, an email is not a duly held meeting, plain and simple. Third, you can't have a quorum of one person. So putting it all together, Mr. Quinn's little vote was totally invalid. In the end, it all came down to this. He just couldn't prove the resignation was ever legally accepted by the board.
And with all that logic laid out so clearly, the final order was short and sweet. Petition dismissed. Just like that, case closed.
Okay, so let's zoom out a bit. Beyond all the drama in this one neighborhood, what's the big takeaway? Why should any of us who live in a community with an HOA care about this case?
Well, this whole story is really a perfect example of why formal procedures matter so much. I know rules about meetings and quorums can feel like a bunch of boring red tape, but they're not. They're like a firewall that protects everybody, making sure decisions are made fairly and out in the open. They exist for one big reason: to stop exactly what was tried here, one person trying to make a huge decision that really belongs to the whole group.
And that really gets to the heart of it, doesn't it? The entire system is designed to stop one person from going rogue. The power is supposed to be with the board as a collective, acting together. That way, every single decision they make is transparent, it's legitimate, and it can actually be defended.
So, here's a final thought to leave you with. This entire months-long legal battle, it all came down to a single clause in one sentence of the bylaws. It's just a powerful reminder that the fine print really matters. So, hey, the next time you get a letter from your own HOA, maybe it's worth taking an extra minute to actually read those rules. You never know when they might suddenly become the most important words in your entire neighborhood.